Here are the basics in a sale of real property. A seller and a buyer sign a contract for the sale of real property. While usually the contract is the first and last step to a transaction for personal property, in a real property transaction, the contract is only the first step. The contract designates some date in the future when the buyer will exchange his payment for the seller's deed, i.e., ownership of the property. This is called the closing of the sale, or closing for short. The time allotted before the closing allows the seller and the buyer to conduct research to assure that there are no unknown issues. For example, the seller doesn't own the land. The contract is the controlling document until the closing. At closing, several things happen. The buyer exchanges his payment for the seller's deed. This is the part of the transaction where we shift from contract law to property law. Thus, we no longer refer to the parties as the buyer and seller. Instead, the parties involved are the grantor and grantee. As a part of the grantee's new ownership of the deed, he now has legal title, as opposed to only equitable title, which he had when the contract was created. Remember that legal title requires that the deed be executed and delivered. Once the exchange is completed, the contract is also completed, and thus the deed becomes the controlling document. Finally, there are three types of deeds: the quitclaim deed, the general warranty deed, and the special warranty deed.